acquired or honed values, principles, and skills on impartiality, independence, integrity, equality, which I bring on the table. My judicial path has taken me far and wide. I have worked almost in all corners of the Republic, Trans Nzoia, Nyanza, Samburu, Eastern, Nairobi, Central, and this has enabled me to embrace diversity, and I'm therefore able to work with all kinds of people. During my years, 31 years, my integrity has remained intact. I have not been subjected to any disciplinary proceedings, and so has my independence at a personal level and even at the institution level. I can say that I'm an effective and efficient judge, as seen from my exemplary performance. I can say that when I was appointed as a judge of the Environment and Land Court in 2017, that's when I started working. I posted clearance rate of 268%, and the person who was following me, or the court following me, was at 134. I predominantly maintained first position on merit productivity for Cycle 3 to Cycle 7 on PMME evaluation, and I did well on backlog clearance. The court was ranked as #1 in one of the cycles, that is cycle number 4. I have even presented the recognition certificate. I can say that I owe this perhaps to my association with a committee known as Active Case Management Steering Committee on Criminal Cases, which I joined at its inception in year 2014. That committee, we deal with issues of expediting criminal trials, but on my own accord, I was able to escalate the skills and knowledge from that committee into the civil process, that is the Land and Environment Court. I apply those skills in my court, and I impact that knowledge even to my colleagues. I've trained magistrates, tribunals, I've trained even the National Assembly, and I've trained globally in that area. And therefore, I believe that is a quality I can be able to escalate to the next court.
Thank you. I think the next set of questions will be followed up by Commissioner Mwanza.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon.
Judge, one of the key attributes of judging or judgecraft is judicial courage.
Yes.
Can you tell us 4 key aspects of judicial courage, and as an experienced judicial officer for the last 31 years, 1 or 2 examples when you've applied that?
Thank you, Commissioner. I can say that one is being independent. At the root of being a judge is independence, where you are able to do your work without any directions, and you just carry that one, you just do your work independently. Then impartiality, you are able to resolve disputes or do your judgment or decision without considering other extraneous factors like nepotism and in such other issues. Another one I can say is just being efficient and effective, because you can encounter a case that is difficult and you lose courage to do it, or you get even afraid. And even being honest to yourself, just reflecting on your weaknesses and seeing whether you can seek advice from a colleague on how to go about such issues. Okay. I have been able to apply this. Yes. If commissioners, you can see the last decision I have submitted, it's a hallmark of courage. The case was in court for 30 years, and whichever judge tried to touch that file, they would find themselves before this commission. So even me, when I received that file, I tried to look at it, but I eventually gave myself, I became courageous, handled it to its logical conclusion.
Okay, thank you, Judge. Judge, you have your constitution there?
Yes.
So I have two questions from Article 19, sub-Article 3 of the Constitution. This is the article that begins with the Bill of Rights. It says that the rights and fundamental freedoms in the Bill of Rights, A, that is 3A, belong to each individual and are not granted by the state. Judge, what is your understanding of that?
My understanding is that these are universal human rights, so you are born with those rights. They are not given by the state.
Okay, they come with you as a human being?
Yes, by being a human being,
okay.
Universal.
Okay. Now, 3B provides that those rights, the ones that are not grantable by the state, sometimes do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are not consistent with this chapter. Do not exclude other rights and fundamental freedoms not in the Bill of Rights. What are those rights and fundamental freedoms that are not in the Bill of Rights?
Thank you, Commissioner. I would say that they include, these are the rights that are outside, including the property rights.
Property right is under 40, Article 40.
Article 40.
Yes. So which are these rights that are not in the Bill of Rights?
But they are in the Constitution.
No. If you read Article 19(3),
Yes.
it says the rights and the fundamental freedoms in the Bill of Rights, A, belong to each individual and are not granted by the state. Yes. You've answered on that. B, do not exclude other rights and fundamental freedoms not in the Bill of Rights. Not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are not inconsistent with this chapter. So my question is, which are these rights that are not in the Bill of Rights? They are actually rights and fundamental freedoms, but they are not contained in the Constitution. Yes. Just give one or two examples, and then yes, that's all. Those will be my questions.
The rights, they are part of the fundamental freedoms.
Yes,
but they are not in the Bill of Rights.
Yes, because the Bill of Rights is quite extensive, isn't
it? Yes, it's chapter 4.
Yes, chapter 4, because it runs from, I think, Article 19, runs all the way, I think, to 50 something. But then the Constitution says these rights that are contained in this chapter, in chapter 4, do not exclude other rights and fundamental freedoms that are not contained herein. They are not contained.
I would say perhaps like the right not to be marginalized, the right to
I think marginalization, the rights against marginalized people is contained in the Bill of Rights.
Marginalization under section under Article 2(4).
2(4).
Yes.
Okay. All right.
Yes.
Yes.
And then also the right to a share of the
the benefits that are given to the counties.
Okay. All right. Thank you, Judge. That's all.
Thank you very much.
Thank you, Honorable CJ, and Judge, welcome once again. The National Land Commission is one of the Chapter 15 institutions in the Constitution, established in the Constitution. This commission has several functions. Can you recall two of them?
One of them is to manage public land.
Yes.
And then, secondly, it's also involved in allocation of that land.
Okay. Then, still on that commission, there was a time where an advisory opinion was sought from the Supreme Court in respect to the functions of this commission. Can you recall what the specific issue in that matter was, and what did the Supreme Court say?
Thank you, Honorable Commissioner. I think that was advisory number 2, and the National Land Commission wanted to take over some of the functions that are undertaken by the Ministry of Land, the Ministry of Land, including imposing the cost or the expenses on land registration and such. It wanted to take over that mandate, and the Supreme Court stated that the two entities should work in harmony, but the National Land Commission's mandate are set out in the Constitution, and the Act they should stick to those mandates.
Okay, thank you. And lastly, let me, in the interest of time, let me just hold it at that. Thank you.
Thank you.
Good afternoon, Judge.
Good afternoon.
Now, in law, enforcement of foreign judgment is the recognition and enforcement in one jurisdiction of judgments rendered in another jurisdiction. So what is the legal regime and the test applicable in the enforcement of foreign judgments in Kenya?
The legal regime is governed by the Enforcement of Foreign Judgments Reciprocal Act.
Any other?
I believe there's also the extradition laws, which are 2. One, the extradition.
No, enforcement of judgments.
Enforcement of judgment. Commissioner, I'm only aware of that one.
What are the circumstances under which a foreign judgment may not be recognized and or enforced in Kenya?
Thank you, Commissioner. Such a foreign judgment will not be recognized if, in the first place, the tribunal or court which gave that judgment had no mandate to do that. Secondly, if in that tribunal the person who is affected was not given notice to appear before that tribunal. Thirdly, if the laws of that other country are inconsistent with ours, they are not in tandem with our laws.
I appreciate. Now let's go back to employment law. A teacher has sued the Teacher Service Commission for unlawful termination of his employment contract on the ground that the disciplinary procedure leading to his dismissal from service did not comply with the rules of natural justice. Assuming that the teacher or the applicant hearing had established that his or her dismissal was unlawful, would he be entitled to orders of judicial review? And if your answer is yes or no, please give us reasons why.
Commissioner, may I request that you repeat again kindly?
A teacher has sued the TSC for unlawful termination of his employment contract on the ground that the disciplinary procedure leading to his dismissal from service did not comply with the rules of natural justice. Yes?
Yes.
assuming that the teacher had established that his dismissal was unlawful before the court, would he or she be entitled to orders of judicial review?
Thank you, Commissioner. The fallback is Article 47 of the Constitution, which is the captures the issue of fair hearing, and in that regard, the judicial review scope has been expanded in the new Constitution, and in that regard, the decision of the Teacher Service Commission can be a subject of those proceedings. And if it is found that the rules of natural justice were violated, then those orders of judicial review will be awarded in terms of Article 23 of the Constitution.
Recently, the Court of Appeal touched on this matter and decided that employer-employee relationships are matters of private law and not public law. And if that is true, what would be the best remedy for an employee who has been dismissed from service?
Thank you, Commissioner.
First and foremost, do you agree that matters of employer-employee relationship are private law and are not public law?
I would say that they are private law, but again, I would say that the Constitution requires everyone to embrace the rights and fundamental freedoms set out in the Constitution.
So if they are private law, would judicial review be appropriate?
I think judicial review would still be appropriate because it's one of the orders that can be given under Article 23.
Okay, let me ask it this way. The legality or otherwise of termination of contracts of employment that have no statutory underpinning are matters of private law or public law?
The legality?
The legality of contracts or termination of contracts that have no statutory underpinning.
Those are private laws.
So when we talk about employer-employee?
It is actually in the habit of private environment.
Thank you.
Thank you, Honorable Chief Justice. Judge, a few questions from me. First, you've been asked about the advisory opinions, and you rightly said advisory opinion number 2, that was in respect of the National Land Commission. How are advisory opinions enforced?
Thank you, Commissioner. The advisory opinions are enforced direct to the Supreme Court, but only by state agencies on matters that relate to county governments.
You may not have understood my question, Judge. You know, when it comes to a judgment of a court, like for instance a judgment from your court, there is a way in which it is enforced. Yes?
Yes.
How would that judgment of your court be enforced?
Those advisory opinions given by the Supreme Court, they are binding, just like any other decisions of that court. So whatever is stated in the body of the judgment has to be implemented by the various entities.
All right, I'll take that, but I was wanting you to say they are authoritative and hence, you know, they must be obeyed.
Yes, they have to. That's why I've said they are binding.
Okay, right. Now, how long have you been in the Land and Environment Court?
9 years. This is my 10th year.
Yes. So I'm sure in terms of experience in that area of the law, you're actually quite experienced. Now, the Land Control Board Act, and in particular Section 6, did make it mandatory that, or still it's mandatory that if you're seeking consent of the Land Control Board, you must do so within a period of six months in respect of a sale, lease, any transaction touching on agricultural land. Why do you think this provision was put into the statute?
Thank you, Commissioner. The statute, quite an old statute, came into force for purposes of ensuring that land is used in an equitable manner. It's managed well to prevent subdivision.
Remember, yes.
Yes.
Don't talk about the entire act.
Yes.
I want us to confine ourselves to Section 6. Yes.
Oh, yes.
That requires that you must seek consent of the Land Control Board in respect of any transaction touching on agricultural land.
To prevent subdivision of agricultural land into very small portions.
That's very correct.
Yes.
That's one. Another one?
And to prevent people from being disinherited.
Again, that is very correct. I'm looking for the final one.
I need to relook at the Act, Commissioner.
Right. Was it also important that we needed to control sale of land to non-Kenyans?
Yes.
All right, so that was the third one.
Okay.
And I appreciate the fact that you say this is indeed a very old statute. So the three things that we've now talked about, the first one, to avoid subdivision into an economical units.
Yes.
Has this provision served its purpose in your own view?
In my own view, Commissioner, I don't think the Act has served the purpose.
No, we are talking about Section 6. I'm not talking about... Even if it was to declare this Act unconstitutional,
Yes.
I think we would be looking at specific provisions, but not
Yes.
maybe the entire Act. I don't want to go that route. I'm just confining myself to Section 6.
I can answer this way. That section has been very problematic because it has been misused.
No, I'm not even going there.
Yes.
I'm just saying, you rightly told us that the reason why that section is there is, one, to avoid subdivision into an economical units.
Yes.
Yes? And the question, and then you have there are two other reasons. So the question is, has this section served the intended purpose in your own view?
In my own view, Commissioner, it has not. Land has continued to be subdivided
Into even smaller units?
40 by 60 pieces of
Right.
land.
And stoppage of unchecked land sales?
That still continues, the unchecked, so it has still not served that purpose.
Is there any provision of the law that has come into existence that has checked land sales?
I would say the courts are, I'm aware the courts are the ones who have come in to tamper or tinker with that section to ensure that justice is done.
What about the provision that says that a man cannot sell land unless his wife has given consent?
Yes, that one.
Yeah?
Yes.
That is under what provisions of, under what law?
I'm aware section 70, I think 79 of the Matrimonial Properties Act.
Is that the one that says you must get the consent of your spouse?
Section 79 of the Land Act.
There's a huge difference between matrimonial act.
Yes, it's the Land Act.
All right.
Yes.
And the third one to control land holding by non-Kenyans? Is there any provision of the law that has taken care of this?
Yeah, there is the Constitution. At least the Constitution says that you can only, the foreigners can only acquire a leasehold interest.
So the purposes for which this section was put in place is no longer there.
It's no longer there, Commissioner,
All right.
to some extent.
Thank you. Thank you.
Chief Justice, just one follow-up from what Justice Sichalo was asking on the issue of spousal consent.
Yes.
You said it was section?
I'm thinking it's Section 79 of the Land Act.
Okay.
Yes.
So what happens if a man is polygamous? How does he get spousal consent?
Ideally, all those spouses ought to give consent. But on the ground, what happens is that usually the man gets the consent from the spouse he likes most.
And what if the transaction is challenged? Say a man has 2 or 3 wives,
Yes.
and one has given spousal consent, and the 2 others have not,
Yes.
and they challenge that transaction
Yes.
based on the 2. Would that vitiate the transaction?
Commissioner, I think there would be a problem because the spouse who gave consent is at par with the other colleagues in that polygamous home. So the others ought to have been consulted. And so there may be a problem.
Okay. All right, thank you.
Am I correct in reading your CV, seeing that you are part of the committee that launched the Adi Sasa platform?
Yes.
Yes. So what was the purpose of the Adi Sasa platform, if you can tell us, share with us, and what challenges are you facing? Is it actually helping?
My association with the Adi Sasa platform came about by me being a chair of the interministerial committee on the setting up of the Adi case registry. That is how I came to interact with the Adi Sasa platform. It is helping a lot because documents, the sanctity of documents now can be ascertained because they are scanned and they are kept in a safe place, which I have even seen through that committee. So going forward, this is going to help if it's rolled countrywide.
Okay, thank you. When it comes to matters of land, which Supreme Court jurisprudence have you found useful on the issues of land, and have you applied any in your day-to-day work in court?
Thank you, Commissioner. The recent jurisprudence from the Supreme Court, I have found them very useful. That is dinner management and Torino, because they do justice and they go to the heart of the dispute, capturing the root of the title. Because we know that land issues in Kenya are very emotive, and fraudsters took advantage of the fact that for many years people just trusted the document of title, and so fraudsters used that jurisprudence to do land grabbing right, left and center. So those decisions are very useful, and I have used them even in some of the decisions I have submitted in this commission.
Thank you.
Thank you, Honorable Chair. Good afternoon once again, my lady.
Good afternoon.
Okay, I've gone through your sample writings. They demonstrate strong grasp of law. You carefully identify issues and give coherent reasoning. Across all the sample writings, you exhibit high level of analytical rigor. The reasoning is evidence-based, measured, and firmly anchored in statute, constitutional provision, precedent, with clear insistence of proof. I would place you as your work around purposive and contextual interpretative policy, philosophy. Maybe you can tell us whether that's factual or not, especially in cases involving public land and surrender of land to public utilities, community land adjudication, and administration of administrative processes. You balance fidelity to the law with substantive justice, demonstrating sensitivity to public interest, historical land injustice,
constitutional competence, and constitutional values. I would cite the example of the Giraffe View Estate Limited matter that involved the sanctity of public land. You went beyond routine application of the law in terms of developing jurisprudence, but you reinforced the place of active case management to curb abuse of the court process. So good job, Judge. So I'll ask you a question with regards to community land. Section 30 of the Community Land Act prohibits discrimination. Subsection 5 of that provision grants automatic community membership to a spouse of a community member. So there is positive and inclusive entry of a spouse once you get married into a community. However, the membership ends upon legal divorce, but for women, when that divorce, when you remarry upon divorce, or when you remarry upon the death of your spouse, you lose your community entitlement. Is this provision problematic? If yes, why? And maybe you can make reference to any constitutional or legal provision.
Thank you, Commissioner. I would say that the Constitution of Kenya prohibits discrimination, and we have Article 27 of the Constitution that factors in the notion of equality. I had an occasion to participate in the review of the National Land Policy, and that was one of the sections that we were interrogating because we found that it was actually discriminative. Okay. Yes.
I'm satisfied with the response. Thank you, and all the best. Thank you, Chair.
Thank you, Chair. Good afternoon, Judge.
Good afternoon.
Yes, in your introductory remarks, you mentioned that you are part of a committee that was dealing with case management in criminal cases.
Yes.
Was that under the auspices of the NCAJ?
Yes, it was.
Okay. So what is the overriding objective of case management in criminal cases, and how do you go about achieving that?
It's just basically expeditious trials in criminal cases, because for many years the criminal cases were bogged down by processes called mentions, kuitika, and they would just drag on forever, and then the small cases or minor cases were mixed with the big cases, such that even if you had a case which is not complex, you would still be in the system for ages because the courts are handling the bigger cases. So in that active case management processes, we have been screening so that the minor cases are dealt with expeditiously, and the complex cases are also dealt with expeditiously without each one affecting the other. We're also dealing with issues of guilty pleas, so that the preparation on guilty pleas is undertaken so that people don't lose their liberty when they come to take pleas. The prosecution is supposed to be prepared. People take plea, they are not put in custody, they pay fines, and they leave. And the final one centered on preparation of the trial. That is then the hallmark of that committee, to ensure that the trials are made trial ready. There is proper preparation, exchange of documents, and all other preliminary issues are dealt with before the trial.
Okay, that is correct, but it speaks only to one aspect of the objectives, yes, according to what your committee came up with, that is expeditious disposal of criminal cases. But there was the other aspect also, if maybe you can share with us.
We incorporated all these other things when now we started working in the committee.
Yes, the other aspect is just determination of criminal cases, yes, and yes, you also had some guidelines on how you go about achieving that.
Yes.
So it is just and expeditious.
Yes, just and
yes,
expeditious.
So what about the justice aspect of it?
The justice aspect is ensuring that justice is achieved through the shortest but fairest route. Yes.
Okay. So I have your performance report here from DISPOP. I don't know if you've been served with a copy.
I have seen a copy.
Yes, and you're happy with it?
And not really.
What is making you unhappy?
Because I found that the rulings which don't close the cases are not incorporated in the merit production.
Yes, they normally don't add those to to merit resolution, because merit resolution takes into account the finalized matters.
Yes,
Yeah, so, but though it's captured, they do capture the rulings that you've delivered that didn't close the cases.
Yes.
So is that the only thing you are not happy about in the report?
It's the only thing.
Okay, so now the report I have here indicates that out of the expected percentage, or the expected merit resolution, you are expected to have concluded 27, but you only had 20 in the period between 2025, or rather financial year 2025-2026, but the period is between July and September 2025. I see you are a single judge in your station, but you have not met the performance targets according to the report that I have. What would you say about that?
Thank you, Commissioner. I can attribute this to shuttling between the two courts, that is Nanyuki and Nyahururu, and trying to find my bearing in the two courts.
In the year 24-25, how many cases, would you know how many cases you concluded in Nanyuki?
In Nanyuki?
Yes.
Not as at now.
Because what I have here says only 4.
For
Would
Nanyuki?
that be accurate? Yes.
No, that cannot be. Yes.
Maybe you need to just discuss this with, because I also found it quite shocking. I've known you for a very long time, and I've always known you to be a hard-working person, even from your magistracy days. And I'm a bit surprised at this, because it says here that for that financial year, your total merit resolutions are only 4 for Nanyuki and 6 for Nyahururu. And I found that to be a bit too low. But maybe you'll discuss with DISPOP and look at what you have and what they have, and maybe supply us with the accurate copy.
Yes, and what they gave me is for up to 2024, not 2025.
No, I'm giving the report in terms of financial years.
Okay.
So this is 2024, 2025. That's where I'm getting the 6 and the 4 for Nyahururu and Nanyuki. But the total merit resolution expected is for the period between July and September 2025, in respect to the current financial year. So maybe you will confirm that and furnish us with a copy.
I will do that, because even in December alone, I delivered 10 judgments.
Okay.
Yes.
Okay then, Judge, I wish you well.
Thank you. Thank you.
Thank you, Honorable Chair, and welcome again, Judge. How do you reconcile oversight, judicial independence, and accountability in the context of resource management? And you could also tell us the checks and balances that exist within the judiciary to enhance accountability.
Thank you, Commissioner. The issue of finances requires all of us to participate, including judges. It's a question of public participation, because even the judges themselves, they use those resources. And then judges are in a position of leadership. So they are in a position to oversight how resources are used, both at the level of the judiciary and even in other arms of government if disputes land in court. Those checks and balances can be found in that, in the event that there are any laws that are made that don't comply with the provisions of the Constitution or other statutes that govern finances, the courts are at liberty to interrogate them and give guidance accordingly.
Does the Judicial Service Commission have any role?
Does
the Judicial Service Commission have any role
in
resources management or in oversight?
Yes, they also have an oversight because they are the employer of they are the employer of the people in the judiciary. So they ought to oversight what is happening, how.
What about in finances?
Even in finances, they do have a role, I believe.
What is the role?
Just to ensure that there is prudent use of the resources that are given, because they are the ultimate employer.
Do they look at the budget?
The
budget, the judiciary budget at all?
The judiciary budget? Let me not do guesswork.
Okay, maybe you can check on that. Now, Judge, finally, what style of leadership do you exercise or do you practice?
Thank you, Commissioner. My style of leadership is transformative, a transformative kind of leadership, which embraces being proactive and being innovative. If I can give examples, in Milimani, when I was the presiding judge, I was able to set up the Land Justice Working Group, which was geared towards finding out the root causes of land disputes in Nairobi County and to come up with appropriate responses. And we have made milestones on that. So I can say I'm very proactive, very versatile in that area.
Okay.
Yes.
Very well. Now, from the background checks and the feedback coming from the stakeholders, some of the stakeholders describe you as very authoritative, and you easily embarrasses advocates, litigants, and prisoners in court. They also say that you are very domineering. How do you respond to that?
Thank you, Commissioner. I can say that I'm none of those things they have said. And perhaps this arises because of my firmness when it comes to how I conduct my trials, especially because of what I've mentioned, my association in the active case management, because I require the parties, including advocates, to comply with court's directions. And this is provided for in the law. So it's just about doing my work. And maybe some people would want to be more relaxed.
Okay. So you're not domineering?
I'm not.
Okay. Okay, thank you, Judge. I wish you all the best.
Thank you very much.
Thank you, Honorable CJ. Judge, I have a few questions for you. Would you please tell us the difference between emotional intelligence and IQ?
Thank you, Commissioner. I would say emotional intelligence is when you use soft skills to deal with a situation, whereas IQ is the actual intelligence on, substantive issues which are not in the area of soft skills.
How would you be able to tell the difference in an individual, that this one is emotionally intelligent and the other one has high IQ?
For emotional intelligence, you need to observe it physically, because you apply it in a particular situation that arises before you, and you know how you now see how to behave or conduct the situation. From the IQ, this can be seen in the written works, journals, and such.
Okay. Have you been in a situation where you've used emotional intelligence to communicate effectively in conflict resolution?
Yes, I have.
You could give us one?
I had a situation where somebody was very sick and was outside the court, and I was not seeing that person, but I was alerted that there is such a person. And when he was brought to court, I told everyone to leave. We remained with just the parties to that case. He was put on a bench, and the parties did not know how to behave. His children did not know how to behave, but I used emotional intelligence, that is empathy and passion, and I told them to first give him water before we could proceed. And we didn't even proceed with the case because I just asked the man, because he was a defendant, whether he had sold the land. He said yes, with difficulty. And I told him why he was not transferring, and he said he needed the trees. The trees were his. So we resolved the case there, and we didn't need to go to trial. So I used emotional intelligence to bring that matter to an end very quickly.
Okay. What are some of the benefits of continuous learning in the role of a judge?
I would say that first and foremost is to keep up with emerging jurisprudence, also to be at par with other stakeholders, the lawyers, also to keep up with new laws, and also to keep up with what is happening in the international world.
Okay. Finally, from me, do you like your job as a judge?
Very much. I don't have any other job. I like it very much.
Okay. Do you like it because you don't have any other job, or?
I have been in the judiciary for 31 years. So this is sort of my home. I love my job. I'm very passionate.
Please tell us one thing you like the most about it.
What I love most or like most about my job is making justice a reality. Just ensuring that the public gets that justice in a manner that we can say it's realistic.
Okay. Thank you, and I wish you well.
Thank you.
Good afternoon again, Judge.
Good afternoon.
Yes, in your current setting, you are the only one making the decisions. Now you are applying to the Court of Appeal, and how do you intend to balance independence of thought with collegial decision making?
Thank you very much, Commissioner. Both of them are very, very important in the Court of Appeal. One, you need to be very, very independent, guided by the law and the facts of the case, holding the fidelity to the law, such that in the event you are not in agreement with the colleagues, you can give even a dissenting decision. But on the other hand, it's very, very important to have the skills, persuasive skills, because this is a collegial court where you will be required to deliver a decision as, you know, as a court with more than one person. So I have skills of collegiality, teamwork, persuasion, and therefore I'd be able to balance both independence and the other aspect of collegiality.
What ethical principles guide your professional relationships with colleagues?
Thank you, Commissioner. Again, I have said that at the root of being a judge is the independence. So once you guard your independence, then it will be very difficult to be persuaded in the wrong direction. You'll be able to hold on to your integrity. You'll be able to be impartial. You'll be able to apply values of professionalism, and you'll be competent. So by and large, you'll be able to hold on to the office independently.
during your long service as a judge or a judicial officer, describe a situation where you have had to acknowledge a mistake in front of your peers. How did that affect your standing?
Thank you, Commissioner. I can say that I demand a lot when it comes to compliance, and so when things are not done as per the timelines, I resort to questioning, and perhaps that has, sort of rubbed shoulders, and I have realized that it's important in an environment where you are working with people to recognize each and everyone's weakness and their strength. And so I now listen more and try to find out why they are not at par with the compliance standards.
Okay, thank you, and I wish you well.
Thank you.
Thank you very much, colleagues and Judge. I think this brings us to the end. But looking at your documents, I cannot see, because one of the qualifications is that you must be an advocate of the High Court. I do not see your certificate of admission. I see also you have brought us copies of your degree certificates, but I recognize you saying that it got lost, and the university confirmed that you actually graduated in 1990, although they don't give another